Good morning, good afternoon, and good evening, everyone. I'm Claire McLeod, LLM Fellow for the Global Center for Environmental Legal Studies at the Elisabeth Haub School of Law. Thank you for joining Climate Change and the SDGs, a book launch and dialogue. I would like to provide a few logistical details before today's event begins. Firstly, please be aware that this event is being recorded. Today's event does include an audience member Q&A session, which will follow remarks from the book contributors and questions from the student interlocutors. To ask a question during the Q&A session, please use the raise hand function. Audience members, please be reminded to mute your microphones during the event until you are called on during the Q&A session. Thank you again for joining today's event. It is now my distinct pleasure to welcome Dean Horace Anderson of the Elisabeth Haub School of Law. Dean Anderson.
Thank you, Claire. Hello, everyone. I'm Horace Anderson, Dean of the Elisabeth Haub School of Law at Pace University. And I would also like to welcome you to our book launch and dialogue for climate change and the sustainable development goals. Today's event is a collaboration among Haub Law, Jindal Law School, and the University for Peace, or UPEACE. As you may know, Haub Law and Jindal Law School in Delhi, India, collaborate through academic and personal exchanges in fields of law, including environmental law and energy law. The relationship enables both schools to teach courses for US and Indian students, to conduct training seminars, and to participate in conferences and symposia organized between the schools in various specialty areas. It also enhances joint research projects focused on comparative law and promotes interaction between Haub Law students and Jindal Law students. We are proud that Tarini Mehta, a Haub Law alum, is an associate professor at Jindal. As for our other collaborator in this event, UPEACE and Pace University work together on mutual programs and learning opportunities for students of both institutions, including dual degree programs, opportunities for UPEACE students to study in New York and for PACE students to study in Costa Rica, as well as new and innovative courses that draw on the strengths of both schools, and the opportunities to publish research through PACE's scholarly journals. With that said, welcome, and it's my special pleasure today to introduce our next speaker, Richard L. Ottinger, Dean Emeritus of the Haub Law School, who has taught environmental law here since 1984 and was dean from 1994 to 1999. He founded the PACE Energy and Climate Center, and he currently serves as co-director of the PACE Global Center for Environmental Legal Studies. He was one of the earliest environmentalists in Congress and authored a substantial number of energy and environmental laws in his 16 years as a member of the House. As chairman of the Energy Conservation and Power Subcommittee of the Interstate and Foreign Commerce Committee, he was instrumental in framing our nation's energy and environmental legislative agenda. Dean Ottinger was a founding staff member of the Peace Corps, serving from 1961 to 1964. Currently, he continues to advise JD, LLM, and SJD students and involve them in his environmental research and presentations. Please join me in giving a warm welcome to Dean Richard Ottinger.
Thank you, Horace. On behalf of our Global Center for Environmental Legal Studies, Professor Katrina Kuh, my co-chair, and I want to extend a warm welcome to all our book launch participants. The two books we are celebrating today are on the most vital subjects facing the world. That on climate change law was co-authored by 5 of our top experts, Professors Kuh, Kaplan, Narula, Rabago, and Vlhova. The other book, Fulfilling the Sustainable Development Goals, was organized by our distinguished senior fellow, Narinder Kakar, who accomplished the amazing task of obtaining as authors top experts in each of the 17 UN-adopted Sustainable Development Goals that define the world's aspirations for achieving a better life for the world's populations. I'm pleased to acknowledge the contributions of our partners in both these publications, the Jindal Law School of Law in Delhi, India, and the University of Peace in Costa Rica. I now have the privilege of introducing you to my longtime friend and frequent collaborator, Narinder Kakar. He has devoted the last 50 years of his professional career to programs related to sustained human development, climate change, and to education for peace building. He has had extensive experience working for the UN, for the University of Peace, and for the International Union for Conservation of Nature. So I'm pleased to turn the floor over to Narinder Kakar.
Thank you very much, Dick, for the effusive introduction. It's commendable that GCELS has organized this panel about the two books that have been published recently. Having been associated with the process for the formulation of the UN Sustainable Development Goals, or SDGs, in 2013 and 2014 in my capacity as the permanent observer of IUCN to the UN, I have had special interest in their implementation. So in 2018, 2019, I felt an urge to do an assessment as to their implementation. With Professor Robinson's support and guidance, we developed the framework for such an assessment. As you know, the 17 SDGs range from ending extreme poverty and hunger, promoting healthy lives, to provision of education, gender issues, reducing inequality, and of course, environmental SDGs for climate change, biodiversity, oceans, sustainably managing forests, among others. We managed to secure the expertise of some very good academics and experts to write papers on each SDG. The book has 35 papers or chapters in all. I'm delighted to see that we have with us in this panel some of those experts who contributed very richly. Dean Emeritus Dick Ottinger himself, Professor Smita Narula, Dr. Mihir Kanade of the University of Peace are with us, as is Dr. Vesselin Popovski of Jindal Global University, who contributed important chapters apart from serving as co-editor of the book. We were also fortunate to get numerous contributions from Professor Morielle, Professor Anna Schotzia, and Professor Lauren Burney from PACE. I would like to highlight that about half of the contributing authors are women, and 4 of them young women, including 2 PACE alumni, Angela Mile and Rela Puno. Now, we could have probably finished the book by the middle of 2020, but coronavirus descended on us in early 2020. We realized that COVID-19 would adversely affect implementation of the SDGs. So we went back to all the authors, requesting them to incorporate a section in each paper, analyzing the adverse effect of COVID-19 would have on their respective SDG and what steps could be taken by countries and societies to minimize such adverse effects. I would like to highlight the following salient features of the book. Number 1, it assesses the progress or the lack of it in implementation of each SDG. It highlights impactful and creative actions that go beyond the usual development efforts and offers expert recommendations. 2, it highlights the interlinkages between different SDGs, emphasizing that lack of progress in one SDG could have adverse effects on the implementation of other SDGs. Number 3, chapter on each SDG shows the way forward, that is, what needs to be done to attain the SDG targets despite various constraints. And number 4, finally, while enumerating general lessons from various studies, the book provides goal-specific recommendations for attaining the targets, pathways to 2030, which is the deadline for attaining the SDG targets. Now, the Deputy Secretary General of the United Nations provided what is referred to as the special introduction to the book, in which she commends the Global Center for Environmental Legal Studies for its focus on implementation of the SDGs, and highlights that the book took stock of efforts to achieve the global targets, and at the same time provided a glimpse of the difficult picture emerging from most parts of the world, highlighting the daunting challenges ahead. Now, before I turn over to Professor Katrina Kuh, I must acknowledge, for which I'm very grateful, I must acknowledge the guidance and support provided by Professor Nicholas Robinson, without which it would have been very difficult to bring this book to fruition. And thanks a lot, Nick, for your support. And thanks also to Dr. Vesselin Popovski for serving as co-editor. Now, Professor Kuh needs no introduction. She is the Haub Distinguished Professor of Environmental Law and a co-chair of the Global Center for Environmental Legal Studies and a contributing author to the book, Climate Change Law, an Introduction. With that, I pass on to Professor Kuh. Thank you very much.
Thank you. Thank you so much, Narinder. Thank you, everyone, for being here. I started my career at a law school that, like many in the United States, where I was really the only professor there who was studying and focusing on environmental law. And by way of background to the book, Climate Change Law, an Introduction, when I came to PACE, I realized there was an entire community of environmental legal scholars there, and that many of us were focused on different issues relating to climate change, but from different perspectives, ranging from land use to regulation under the Clean Air Act to the intersections of climate change with human rights law. And something else that became clear to me is that as we orient from a period of talking about climate change to actually trying to implement solutions in a more meaningful on-the-ground way, there's been a rising interest in understanding the law and policy relating to climate change, not just from current JD students whom we're teaching, but from many who went to law school before climate change was a significant area of study. Many who are policymakers who may not even have a law degree, but are working in the climate change space, and concerned citizens who are eager to become knowledgeable about climate change because they understand it to be a significant aspect of responsible citizenship today. So the motivating force behind Climate Change Law, an Introduction was to bring together professors, current and former colleagues from PACE who were working on climate change issues from different perspectives, and to author a text that would quickly provide an entree and an overview of climate law and policy for individuals interested to come up to speed. And so I'm very pleased to have worked with these collaborators and hopefully produced a text that will provide an introduction to climate change for many who are interested to learn more. Another enormously unusual and wonderful aspect about being at PACE is our connections with international environmental law, international environmental law scholars. And in light of the clear connections between climate change and the Sustainable Development Goals, it seemed fitting to hold an event to talk about some of the work streams that our faculty are doing, particularly in light of the strong partnerships between our schools. So hopefully we'll have a productive, very exciting discussion today. about the overlap between these two books and what they study. So what I'd like to do first is to introduce our panelists. Our panelists are all contributors to one, or in some cases both, of the recently published books, the SDGs book and the Climate Change Law. And the Climate Change Law book, Dr. Mihir Kanade from UPEACE is the academic coordinator of the University for Peace, the head of its Department of International Law, and the director of the UPEACE Human Rights Center. He currently serves as a member of the United Nations Human Rights Council on the expert mechanism on the right to development. And he also chairs the drafting group of international experts appointed by the Office of the High Commissioner for Human Rights for preparing a legally binding instrument on the right to development. Professor Dr. Vesselin Popovski is the Vice Dean and Professor of Law at Jindal Global Law School. He serves as a member of the advisory board of the Journal of International Humanitarian Legal Studies and the editorial boards of Journal International Studies Review and Sustainability Science. And he has contributed to two major international initiatives, the International Commission on Intervention in State Sovereignty and the Princeton Project on Universal Jurisdiction. And of course, there's my colleague, Professor Smita Narula. She is the Haub Distinguished Professor of International Law at the Elisabeth Haub School of Law at Pace University and co-director of the Law School's Global Center for Environmental Legal Studies. She previously served as legal advisor to the UN Special Rapporteur on the Right to Food and co-founded the International Dalit Solidarity Network, which fights caste-based discrimination. She was also recently elected to the American College of Environmental Lawyers. So with that, I'll turn the floor over to Dr. Kanade, who will be giving, and each of our panelists will be giving some of their thoughts on the intersections between climate change and the Sustainable Development Goals. Dr. Kanade.
Thank you very much, Katie, for the kind introduction, and thank you to all the colleagues at Pace University for organizing this event and for inviting me to be a panelist, along with other distinguished colleagues. I think it's quite clear that climate change and sustainable development share a mutually dependent and symbiotic relationship with each other. The relationship between climate change and sustainable development is mutually dependent and what I also call often as symbiotic with each other. It's a dual relationship. This is recognized both in the 2030 agenda and also in the Paris Climate Agreement, which in particular underscores this nexus through references to sustainable development in numerous recitals and provisions. Now, the one thing I would highlight of this nexus, and I'd like to flag this up front, possibly for a discussion later, is the indispensability of international cooperation to both adapting and mitigating climate change and the realization of the Sustainable Development Goals. The Paris Climate Agreement acknowledges that climate change is a common concern of humankind, indicating that no single state can address it on its own. It's a transnational problem and needs international cooperation. This international cooperation is manifested in many ways: information sharing, technology transfer, capacity building, financial support to developing and vulnerable states, such as the small island developing states. The 2030 agenda also is predicated on the importance of a global partnership for sustainable development through the realization of what are called as the means of implementation goals and targets. So as some of you will know, SDG 17 and its 19 targets are identified as the means of implementing all the preceding 16 SDGs. In addition, each of the first 16 SDGs contain numerical and alphabetical targets. And these alphabetical targets, or the ABC targets under each of the SDGs, contains the means of implementing that specific SDG and its numerical targets. So collectively, these 62 means of implementation targets in the 2030 agenda are all based on international cooperation that are the key to the realization of the SDGs. Now, the question, of course, is how do we conceive of international cooperation in the context of obligations of states under the Paris Climate Agreement and under the other multilateral environmental agreements, as well as in the context of the commitments of states under the 2030 Agenda. In my personal academic and professional work, as well as a member of the United Nations Human Rights Council's expert mechanism on the right to development, I've found that as a regular practice, international cooperation is often framed or viewed through the lens of charity or generosity rather than as a duty of states. And this is where the framing, at least in my perspective, of development itself as a human right is quite useful. The right to development as a normative framework insists that development is a human right of all individuals and peoples, that development is a comprehensive process aimed at the constant improvement of the well-being of all human beings and peoples. It rejects, almost in an Amartya Sen style of argumentation, of equating development with economic growth only. It insists that development as a human right needs to be sustainable, and that there is an inherent duty of international cooperation that states must discharge. In other words, like climate change, development is also a common concern of humankind. And as some of you know, I chair the drafting group of on the legally binding instrument on right to development, and the first preambular recital that we included is also inspired by climate change debate. And we have said that development is or realization of development is a common concern of humankind. So in my opinion, to conclude, I would say that neither action on climate change nor sustainable development can be effectively addressed unless international cooperation is viewed from the lens of duties. Unless this duty is operationalized in the true sense, we will unfortunately continue to witness unmitigated climate change and unsustainable development. That's the business as usual approach as we have it today. Thank you.
Thank you so much, Dr. Kanade. Dr. Popovski, I'll turn the floor over to you.
Thank you so much. And I would start with expressing my deep gratitude to the Elisabeth Haub Law School for bringing Jindal Law School into the project, and specifically to Narinder Kakar, who approached me initially to write the chapter for the book on climate change based on my previous book, Implementation of the Paris Agreement on Climate Change. But gradually we were involved more and more into the book with additional chapters. And I must say this is a very special moment for me and for my team in Jindal Global Law School, because we really appreciate the cooperation we developed since then, which in fact developed further than just this book. And now our two institutions have a common memorandum of understanding. And I really admire the energy and the enthusiasm of Narinder in particular, but also everybody else. We sometimes were on the phone call every week, even several times a week. Even my mother, who is 85 years old, will say, Narinder was calling you, you should call him back. She wouldn't remember anything else, but she will remember that I have to get back to a call with Narinder because that's urgent. This book is really special. I must say the idea to bring 17 goals into one book in a pandemic environment, but also to focus on implementation, which is the most difficult part of every project, because usually scholars prefer to argue about concepts and theories and ideas, but to talk about specific implementation problems, I think we were the first one to address that. And let me say several lessons that we learn out of this book. The first is that managing complexity and building resilience are really the critical elements of policy making for sustainable development. The sophisticated interactions between various goals and dimensions is so important as to understand those complexities. And exactly because uncertainty cannot be controlled, the only alternative to that is to manage complexity. We see how important becomes the building of resilient societies, critical not only to our ability to respond to crisis, but also to achieve the sustainable future. And a society can become resilient only when it has the ability to face the shocks and the persistent structural changes without losing ability to deliver on the well-being for the community in a sustainable way. And not surprisingly, the last IPCC report only a week ago, the sixth assessment, 3 working groups also emphasize resilience in addition to risks and adaptation as a major issue here. The second lesson is that we need a continuous global coordination, but in addition to that, we have also to have the local feedback. And what our book did is admirably to focus on developing countries, to extract some specific practices that really build the resilience, the adaptation. So solutions to crisis are most effective exactly when they are locally informed. The next lesson is that to achieve the Agenda 2030, it is very important to connect to the public, to connect to the regular people, to people's needs, not only to politics and high-level policy making, but to be able to create this multi-stakeholder approach, including the youth, elders, women, indigenous people, as a requisite to overcome the disconnection between scales and actors. And there has never been so much creativity, talent, think tanks, mobilized citizens, UN agencies, programs, regional commissions, proposing innovations, alternatives, and options as to achieve sustainable development. The next lesson is that leadership is strongly needed, but it needs, again, to come from the whole of the society. It's not only governments or messianic leaders. Numerous social activists, women, journalists, opinion makers, scientists, indigenous leaders. Everyone has a role to play in building a new social contract between society, economy, and nature. And here we had another paradox, the wealth of ideas and proposals, but on the other hand, the shortage of political will and decisions to collaborate, to have a shared visions. So we really need a multilateral system which is inclusive, efficient, relevant, accountable, and truly connected to people's needs and expectations. And finally, and very importantly, I think the SDGs must be informed by human rights obligations. And that includes the full spectrum of human rights, the civil and political rights, the economic, social, and cultural rights. And as Mihir Kanade just said, the already important and recognized third generation rights, such as the right to development, right to clean environment, the right to international solidarity, which Mihir and I are currently also developing into another project. So the uniqueness of the moment is that we can utilize the COVID-19 crisis and lessons as to do better in the future. So there is absolutely shortage of time as to be somehow reliant on what we need to innovate. We need to not simply, and importantly, what the IPCC report last week said, the resilience is not only to survive, it's also the ability to transform. We need to think about capacity to transformation as an important ingredient in resilience. And I hope that also could become another driver of the achievement of the Agenda 2030. I'm sure there might be many questions from our audience. I will stop here and wait for the questions as to give you a little bit more from my own excellent experience to this project. Thank you, Narinder. Thank you, Elisabeth Haub School. It was a great pleasure to work together. I hope we continue in the same vein in the future.
Thank you so much, Dr. Popovski, and you've given us a wonderful segue to our next panelist, Professor Narula.
Thank you, Professor Kuh. I was just thinking the same thing. What a wonderful segue Professor Popovski and Dr. Kanade have provided. So I have the unique pleasure of being able to say that I contributed to both volumes and was able to do so alongside such incredible and wonderful colleagues, and wanted to especially thank Professor Kuh for her leadership on the climate change law book and pulling us all together into this project, and Professor Kakar and others, Professor Ottinger, Dr. Kanade, and also Professor Popovski for all your efforts and support and leadership on the SDGs book. For me, both of the books and being able to work on both really honed in for me what Dr. Kanade was saying, that this really is this climate change and sustainable development are symbiotic. The relationship is symbiotic, and similarly can also be very parasitic. The undermining of climate stability undermines sustainable development. Advancing development in unsustainable ways advances climate threats and climate instability in society. What I especially appreciate about both volumes is their contribution as teaching tools, and not just to lawyers, but to policymakers, to students. We focused a great deal on the ability of the climate change book, for example, to advance climate literacy and be really accessible to others in thinking about how law can be used as a framework to advance climate change solutions and climate justice. And the SDG books, I remember early conversations with Professor Kakar, where I was so appreciative of his framing of each chapter as not only tracking the implementation of each SDG, but also highlighting case studies where progress has been made and where lessons can be learned. As Professor Popovski just said, there is no dearth of innovative ideas and leaderships in the interstices of this global economy that are emerging everywhere in response to these existential threats that we're facing. I wanted to frame my own remarks in the context of the IPCC report that's already been mentioned. It's an alarming report, and we're living through some very alarming and frightening times, but it also holds key insights, I think, for the direction that we must take. And I'm going to use a couple of its key takeaways to frame my own remarks. First, the report frames itself as having a particular focus on transformation and system transitions in energy, land, ocean, coastal, and freshwater ecosystems, urban, rural, and infrastructure, and industry and societies. Essentially, and I'm still making my way through the very voluminous report, the report is calling for what is being called for, and indeed what multiple reports have been calling for, is transformative systems change. We can no longer simply proceed with business as usual if we are going to achieve the Sustainable Development Goals and if we are going to address climate change. What does that look like? I think maybe all of us have different ideas of what that might look like. But for me personally, in reflecting on the relationship between climate change and sustainable development, my own view is that we cannot continue with an extractive fossil fuel-based system that is premised on endless economic growth on a planet with finite resources and that violently reproduces hierarchies based on gender, caste, race, indigenous status, sexual orientation, disabilities, and other categories that make it so that particular communities and entire countries suffer far more harm than others. As has been said very eloquently by others, we may all be in the same storm, but we are not all in the same boat. And what's exciting to me about the IPCC report is that there's a very profound recognition, not just of the need for systems change, but also of the need to center climate justice and issues of social equity, and calling for adaptation, not just in the near or short term, but for transformational adaptation. So this isn't just about building seawalls, it's about focusing on systems change and focusing on the social inequities that are at the heart of climate change and that give rise to calls for climate justice that must be addressed front and center. The report then goes on to define climate justice as comprising justice that links development and human rights to achieve a rights-based approach to addressing climate change. And the other panelists have also already spoken to the importance of human rights in this conversation and of rights-based approaches to development, and I would say also to addressing climate change as a means of centering our understanding of the path forward. The chapter that I contributed to the climate change book was focused on human rights and climate change. And in addition to chronicling the impact of climate change on human rights on a range of communities, including the disproportionate harm suffered by particularly marginalized or vulnerable communities, I also tried to show that states' obligations to mitigate and adapt to climate change have also evolved tremendously, and that there are real benefits of pursuing a rights-based approach both to climate change and to development. Namely, a rights-based approach helps to center government accountability to people and the planet. It insists on procedural justice, namely that those who are most affected must participate in the decision-making around policies that affect development and climate change. And it insists on distributive justice by calling on states to address specifically the needs of those who are most vulnerable to the climate crisis. Central to our discussion today is the fact that the IPCC report also labels the process of implementing mitigation and adaptation together in support of sustainable development for all as climate resilient development. And I think there could be many conversations on what climate resilient development actually looks like. The report does note that it includes an emphasis on transformative adaptation, systems change, and on social inequities. I'll conclude by saying that all of this sort of came to fore in the chapter that I was really honored to be able to contribute to the SDGs book, which looked specifically at SDG 2 on achieving zero hunger. In that chapter, I explored issues of justice, social equity, and the needs for system change. And I argued that, or tried to bring into view, the transformative changes that are needed to build food systems that are sustainable, nourishing, and just, which in turn can help achieve SDG 2 and related goals. Specifically, I argued, as many others have, that we have to reject destructive agricultural practices and embrace a rights-based approach to achieving food security and promoting sustainable food production. And that this in turn requires shifting from industrial agriculture to diversified agroecological systems, but it also requires global recognition of the communities that feed us, namely recognition of the rights of peasants and other small-scale food producers who ironically also form the majority of the world's food insecure. So I would just conclude by saying, to me, this very profound interdependent relationship between sustainable development and climate change is tied together for me in two key concepts. One is that social inequities and in turn social justice, climate justice, are at the heart of both endeavors. And secondly, that the need for systems change that reproduces so much harm to people and the planet also has to be at the heart of climate change policies and sustainable development. Ultimately, we need to really think through what our definition of development is in order for it to be sustainable, in order for it to be just, and not just to humans, but also to all non-human life on the planet. My thanks once again for this wonderful opportunities to work on these incredible projects, and to Claire and Professor Kuh and Professor Kanade for organizing this wonderful event.
Thank you so much, Professor Narula. I think our panelists have given us a lot to talk about, and student interlocutors, thank you for your patience. Our goal in building partnerships around the world is in part to connect faculty and to inform one another's scholarship, but it's also in part to connect the next generation of scholars and professors who will study and work on these issues. So we're very excited to invite students from Jindal, UPEACE, and PACE to present questions to our panelists. Our student interlocutors are Ankit Malhotra from the Jindal Global Law School. Ankit is currently an LLB student at Jindal Global Law School. He has a Bachelor of Arts degree in International Relations from the Jindal School of International Affairs. And during his bachelor studies, he co-authored a paper on India-China rivalry in South Asia. So I'll turn the floor over to Ankit to pose the first question to our panelists, and thank you so much for being here.
Well, let me begin by thanking Professor Popovski for giving me an opportunity to work with him, as I have on so many other occasions as well. It's always a deeply inspiring and motivating sentiment when I'm working with him, especially. I've also worked with him on a chapter on Raphael Lemkin and his work, and we have our own society which he spearheads so profoundly and deeply, and inspires us as he does with his writings as well. My question is really stemming from where we started off, perhaps even before the session started, when we're discussing the role of international environmental law as a theoretical or conceptual framework, but not existing in a certain system or a certain law, but just existing in an abstract or a vacuum. I do find that slightly problematic, because at the end of the day, we're all lawyers. We need to try and hold someone accountable for something, and we need to do it in a certain perspective or format and say, okay, A is responsible for B. But if this does not exist, then the whole system sort of tumbles down on one top of the other. In this sense, perhaps climate change and the sustainable goal number 15 makes most sense to me. And I would feel that ecocide then perhaps comes as the resounding answer to this. And I'd be very interested to see the global cooperation and effort put forth for this, because as we speak, countries being invaded, and I think what a net effect out of that has come, although it is very negative, is that global cooperation is seen as sort of a renaissance. I think there is a lot that one can get from international cooperation in the face of mass atrocity. So I'll stop there, and I once again thank everyone for this opportunity. Thank you.
And so I would invite Professor Kanade, Narula, Popovski, whoever is interested to respond to Ankit's provocative kind of question. I think centering on ecocide as a potential tool to address some of these issues more directly. Please feel free to jump in.
Smita, would you like to go first, or? All right. Well, thank you, Ankit, very much for the provocative question. I think you've hit the nail right on its head in terms of the role of international environmental law in general. It reminds me of the 2006 report of the International Law Commission on fragmentation of international law. And a key point that the International Law Commission was making there was with reference to these very vague labels that we attach to different legal systems in international law, what we call as international environmental law or trade law or human rights law, are more labels that are informally created by interested caucuses and lawyers, rather than as a systemic way in which international law organically comes up with such rule systems. And what I'm pointing out here is that the example that the International Law Commission gives is that of maritime transport of oil, and very provocatively asks us, if we are going to look at the obligations of a ship owner with relation to transportation of maritime oil, our answers to that question would differ depending on what lens we adopt. If you're looking at that answer from the environmental law perspective, we are likely to come to a different result as if we are answering that question purely from the perspective of trade law or commercial law, or even law of the sea. And this is a problem of fragmentation that the International Law Commission was pointing out. So I think the key point here is how to address and bring about harmonization of the different legal regimes. And some interesting and important ways have been suggested already in the discussion today. Smita mentioned the human rights-based approach towards addressing climate change. We, of course, now have a framework from the Human Rights Council in October last year, where for the first time at the international level, the right to a safe, clean, healthy environment was recognized as a human right. And I should say first time at the international level, because it's not like this right did not exist. In 1981, this was recognized by the African system. So it's only from a Western perspective, which continued to have a deep resistance to, what, again, in a very, I would say, problematic way, the Western concept continues to label as third generation rights. It's third generation only in a Western construction. It's first generation in other societies. Whether we think of right to development, right to environment, right to peace, these are only third generation in a Western construct. So anyway, we do have very important ways of bridging these, what otherwise is a problem of fragmentation. In my work, I have, as I pointed out, found it very important and useful to identify what needs to be done in order to address these problems. And it's quite clear that it's international cooperation. You mentioned that in your question as well. The problem, of course, is, are we going to continue looking at international cooperation from the business as usual lens of charity, whether it comes to climate finance, whether we talk about the Green Fund, we talk about technology transfer. Are we going to look at it from the lens of charity, generosity, which essentially puts the donors in a position of controlling what the conditionalities would be? It takes away the agency from the recipients in determining the sectors that they want the development cooperation to go in. Or are we going to transform this and look at international cooperation from the lens of a duty? None of this is really novel. The normative basis for international cooperation being a duty of states is inherent in the UN Charter. There are at least 3 provisions. Article 1, Article 55, Article 56 make it a duty on states to cooperate with each other for realizing common problems, that are common concerns of humankind. Then a final note on ecocide, that is yet another way in which one could criminalize, at least make it an international crime, serious violations or destruction of the environment. I've often said provocatively in other forums, looking at the policies of the President Bolsonaro government in Brazil of cutting down the Amazons for whether with relation to converting them into pastures or mining or what have you. I think at some point the world needs to move towards a recognition of the Amazons and many of these large forests as a common heritage of humankind, removing them from exclusive sovereignty of a particular country. I know how provocative this sounds, but I think considering the very importance of these, the Amazons, for instance, for the life of the entire planet and its survival, there will be a time when we will be moving towards, questioning state sovereignty over something as fundamental as this. So I'll stop there with my comments and probably pass over to Smita.
And I think in the interest of time, we may need to move, and Professor Narula, I'd invite you to offer some thoughts maybe in response to our next panelists. So I'd like to introduce next Tiyamike Mkanthama, who is currently pursuing a doctoral degree in environment development and peace at UPEACE. He already holds a master's degree in environment development and peace from UPEACE, as well as a bachelor's degree in social sciences with a specialization in sociology and industrial relations from the University of Malawi. So welcome and thank you very much for being here. And please offer a question to our panelists.
Well, thank you very much for giving me this opportunity to participate in this event. And it's quite interesting just hearing your thoughts of the 2 volumes that have been published, and to see how they're not only multidisciplinary, but they're also an intersectional lens through the themes that are discussed. And this is quite interesting. I look forward to learning more about these or even reading through these volumes. So thank you very much. Actually, the main question I had, I felt like was somewhat touched on with regards to financing, because I was just very curious about whether when the so-called developed countries make promises, you can see this at the Conference of Parties all the time, where they make promises to finance efforts in the global South. I always feel, is this really getting to the point? Because these countries are one of the biggest emitters of greenhouse gases. Should they not themselves redress that aspect, that they're emitting more greenhouse gases, and not necessarily just make it a point like, oh, but we're financing the efforts to adapt or to in the global south. So I always feel, is this just a moral obligation that they have, or should they take it upon themselves also to actually, it almost feels for me sometimes it's like, why not pull the plug and address it directly from the source? So this was somewhat, I feel like, touched on, but I would still want to hear more about it. And also just a general question that when I teach a course in environmental sustainability and development, some of my students are always curious about if we're ever going to achieve the SDGs, since we only have about eight years to go, and it doesn't seem like we've made a big difference. And it's hard for me sometimes to make it more hopeful for them to say, no, there are actually some things that are being addressed, and so this challenge is also something that I get. So I want to still hear from you and on that aspect, and to whether SDGs sometimes miss the mark with regards to inequalities. I sometimes feel like there is a lack of addressing directly the social and political inequalities that exist. So these are just some of my thoughts scattered as they are. They're some of the questions that keep me awake at night as to whether we're making headway. So thank you.
Wonderful, thank you. I think they keep us all awake at night. So Professor Narula, maybe I'll pass the baton to you first.
I do indeed stay awake at night thinking about those same questions. I'll tell you what helps me sleep, however, which is that there is also enormous courage and transformation that's reflected in the law. And by the time something actually reaches the point of becoming law or being proposed as law, it's usually had to travel through many social movements, many actors who have really tried to push a very different narrative in the context of international law. Dr. Kanade already said international law is often quite slow to these recognitions, including, for example, on the right to a healthy environment, which has been recognized in regional and domestic systems for decades, and is reflected one way or the other in the laws or constitutions of more than 150 countries already, something our visiting professor, Jimmy May, has worked a great deal on. I think that there is, by the time that ECHO reaches international law, it is building on huge systems of resistance in wanting to redefine the narrative of who's responsible and what action needs to be taken. And here I also really appreciate Dr. Kanade's interventions about the different perceptions of both the problem and the solution from the view of the global north and the global south, including communities that are marginalized within both the global north and the global south. The need to reframe the financing as an issue of legal obligation, even reparation, and as an issue of climate justice, as opposed to an issue of charity, is something that many communities, countries, and groups have been pushing. The ecocide piece, just to tie this back to that, I feel like is also a way in which we as lawyers are looking for legal tools to increase accountability. And this move to try to amend the sort of jurisdiction of the International Criminal Court to be able to also prosecute for crimes of ecocide, I would look at it as one potential tool in a really varied toolbox that also includes the right to a healthy environment, that includes climate litigation using rights-based claims in high emitting countries that are succeeding at starting to get accountability in those countries. I see the law as a tool in climate litigation against corporate actors, which is also finally beginning to find some traction, not here in the United States, but certainly in Europe and elsewhere. And I see the law as also fundamentally the most important in both having international law as a place for that global cooperation, but also as a means of achieving a dramatic shift in narrative and understanding what the problem is and what the solutions are in terms of being able to sleep at night and how far we've come I also point to the many examples of cooperation within the law, without which, we wouldn't have a healing ozone layer, for example, above our heads. We talk about the Montreal Protocol and the Vienna Convention a lot in my international environmental law class, but also as a means of changing societal minds and culture. The rights of nature, the rights of indigenous peoples, the need to center those voices is increasingly also being reflected in international environmental law in a way that's really an echo of what's already happening domestically in very promising ways.
Wonderful, thank you. And I'd invite Professor Popovski and Kanade to offer a response as well.
Definitely. I also cannot sleep at night at some time because the expectations were not met, and every next report the IPCC comes up with, we see that the picture is darker and darker. However, I also agree that there are some lights in the end of the tunnel, coming mostly from states that recognize the commitments and they actually made the ambitions higher. But also, as Smita just said, there are judicial pressures coming from so far only domestic courts. Ujendra versus Netherlands was really a breakthrough decision when an NGO representing 866 citizens in Netherlands successfully challenged the government and the insufficient commitment of the Dutch government to reduce emissions. And that was really surprising. I remember waiting for that decision. Usually judges are conservative people. They don't want to operate in uncertainty. They want very hard, solid evidence. And when you go to the judge and say that the future generation will suffer from now on because the governments do not meet their ambitions, all this sounds quite vague and quite ambiguous for judges. Usually they don't like to operate in uncertainty, in vagueness. But nevertheless, that decision in the Dutch court on Ujendra case, I think is really wall-breaking, because after that we see the same in several other jurisdictions, in Belgium, in Norway, in Germany. And I agree that what we really need is an international environmental tribunal. Here I will probably be a bit more skeptical about whether we can enlarge the jurisdiction of the existing International Criminal Court. And I doubt that. Even that court has quite a lot of political and other problems. But what we really need is a separate, special International Environmental Tribunal, which will be really expert-based, specific on the type of commitments and on the type of accountability we are looking at here, because ecocide will be difficult to prove in the ICC. I'm very honest with you that let's not push what probably will not happen. So more realistically, we need to gather our energy and our civil movements around the idea of a new international environmental tribunal to be specifically addressing environmental crimes. And I hope that way we can achieve more. And I fully agree that financing is crucial. The commitment should come not as a charity, not as philanthropy, but rather as understanding about the accountability for the past, for the intergenerational justice, North and South. The polluter pay principle is very relevant here. So that is the scope of arguments that could be made as to extract extra implementation from states that are probably reluctant to cooperate. So I hope in that direction we can achieve more.
I'd just like to comment on the last question that Tiyamike asked, and because the other one on climate finance and the aspects of reparations, remediation have already been addressed by the previous two speakers. And this was about the 2030 agenda and how off track we are on it in the remaining 8 years. Is there any prospect of bringing it back? In the first thematic study of the expert mechanism on the right to development that we submitted to the Human Rights Council, and that was my report on behalf of the expert mechanism. We pointed out that the 2030 agenda was already off track even prior to the COVID-19 pandemic, and not just off track in the sense that every single goal, every single target had decelerated every successive year as compared to the previous year. And this is until 2019. And of course, we know that the COVID-19 pandemic derailed it even further. But what's even more interesting, and this is where the connection I was trying to make in my initial address between the means of implementation targets and the SDGs. As I pointed out, there are certain targets that are specifically earmarked, they're specifically separated in the 2030 agenda. And they are called as the means of implementing targets, meaning that unless you realize these targets, it's impossible to realize any of the other SDGs. You find those in SDG 17. In addition, each of the SDGs also has those alphabetical targets. Now, what we found out is that there was a deceleration in every single means of implementation target. And therefore, it's no surprise that the rest of the goals and the rest of the targets also decelerated. And what are these means of implementation targets? They're all based on global partnership for development and international cooperation. The whole fundamental premise of the 2030 agenda is that no state is going to be able to realize its SDG commitments on its own. You need a global partnership for that. You need international cooperation for that. If that was not present, even prior to the pandemic, if that had decelerated, how do we possibly make sure that the goals and the targets on which they are based are also realized? There are two ways of looking at what can be done in the remaining 2 years. There have been some scholars who have pointed out probably we need to push the goalpost a bit further and instead of 2030, make it 2035, 2040. That's not a view that I personally subscribe to. I'd rather go with a view that some scholars like Jeffrey Sachs have pointed out that we need to identify where we went wrong in the pre-COVID times and the COVID times, understand what needs to be done to bring the agenda back on track and double down on it in the remaining years. And I think that's a more productive way of answering the question rather than pushing the goalpost even further. And I'm pointing out here at really looking at the duty of international cooperation much more seriously. And that's what I also tried to contend in my chapter for the SDGs book.
Wonderful, thank you. And I'd now like to introduce our final student interlocutor. Akinola Afolar is a graduate of Olabisi Onabanjo University and Nigerian Law School. He has 10 years of practice experience in Nigeria and is now an LLM candidate in energy and climate change law at PACE with a focus on the impacts of climate change in Africa. He is co-vice chair for the American Bar Association section on Environment, Energy, and Resources Law, International Environmental and Resources Law Committee. Welcome, Akinola. We look forward to your question.
Thank you very much, Professor. And I especially want to thank you for this opportunity to be part of this discussion. I never saw it coming, but I'm glad that I am here. And the conversation has been really impactful for me because some of the issues that are being raised here are issues that are really, really dear to me. I will start by addressing the issue of climate change, and which is something that is very, very dear to me. Because now when we look at the climate change treaties that we have, all of them, they are all premised on the obligations of the states to mitigate emissions in their different countries. But what we have seen is that many states, including the United States, incidentally, have not been able to come up with public laws that can actually effectively mitigate climate change in their respective countries. Now, where that has left us is we continue to just hope that something will happen depending on individual activities, but that has not really helped. Now, let me go to what Professor Narula said. She mentioned the issue of the fossil fuel industry, which is also an industry that I am also really particular about. Now, the Climate Accountability Institute recently released a report that shows that the carbon 20, that is the top 20 fossil fuel countries in the world, their emissions, both historical and current emission rates, make up to 35% of the total emission that we talk about globally. If we expand that number to 100, it gives us at least 71% of the total emission that we have. And it appears nobody is doing anything to arrest the situation. When the governments are not, when the states that are parties to these treaties are not making public laws to mitigate the emissions and control the activities of these fossil fuel industries, it continues to become a problem. Now, because of that, we have seen activities of individuals or private climate governance coming up with issue of divestments, shareholder activities, and other things to make sure that they put pressure on these private actors. But even that, I'm not sure has really helped, as Professor Popovski also made mention in his article on climate change and SDG. We found that even, and this is also supported by the reports of the SDG goals of 2020 that shows that investment in fossil fuel continues to surpass investments in climate mitigation investments. So we continue to expect that solution is going to come, but we'll continue to invest in the industry that continues to contribute to the highest number of emissions that we have. Now, the question I would like to ask the panel is, now this government, this private governance that we have, issue of divestment, shareholder activism that is putting pressure on the fossil fuel industry. How far do we really think they can go, and what significant role do we think they can make in mitigating climate change issues that we have? Again, I'm also looking at, is it possible, because the SDG goals have not really succeeded, as Professor Popovski also made mention in his work, that we have not really succeeded. Now, is it possible to also employ this private climate activism that we have, like the shareholder activism, divestment, and all of that? Is it also possible to employ that to put pressure on private actors so that they can support the SDG goals? And thirdly, I know that the more we continue to push these private climate actions or governance, it may get to a point where it can also become a problem. So do you see any problem or any risk as time goes on, the more we continue to employ this, especially where we don't have the government that is in support or making the public law that is actually necessary to mitigate climate change? Thank you.
Wonderful. Thank you so much, Akinola. I'd invite any of our panelists who'd like to dive in to consider. Yes, Professor Popovski.
Thank you. Excellent question, Akinola. How to make the private sector accountable for lack of reduction of emissions. And it's a perennial problem in international law, because usually, as you said, it is a commitment by states, but do states really delegate those obligations back to the large industries domestically? How do they regulate domestically? How do they extract compliance with private actors? Specifically, when it comes to climate change, the big fossil fuel industries are crucial. If as you said, if they make a small reduction even of their carbon footprint, that will be enormously important. And one way to do that is to bring together private and public sector into partnership even in the process of negotiations. In several other forums in the United Nations, we achieved that. There is a global compact. There is quite a lot of commitment in terms of peace building activities, where the private sector, even individual donors play quite a good role. engaging examples of successful sustainability models coming from large companies and the private sector has also been achieved. Unilever did a lot of action, not specifically on climate change, but the model, the framework which they establish elsewhere could also be very useful. And I will also point to the what I will call reputational cost. Accountability works when companies see the benefit, but also the benefit depends on the reputation. In other words, here comes again opportunities such as incentives, but also naming and shaming and extracting reputational cost from companies if they do not cooperate with the climate policies and agreements. So I will go both ways. Incentives are important, certification, licensing, regulations, adopting all possible domestic regulation as to make private companies compliant with the carbon reduction, but also exercising, in addition to incentives, also some sort of pressures and reputational costs if they do not comply. So both ways, pulling and pushing, probably is the model here. But excellent, we need to do more. I agree with you. Your question actually is advocacy to do more in this regard. I totally agree.
So I'll jump in to add a few more points in addition to that. And I would recommend everybody watching the recording of our recent Carlin lecture, which actually looked at this issue of corporate social responsibility in the context of climate change. I would say, private sector accountability and corporate accountability continues to be the Achilles heel of international human rights law, which holds state actors, but not non-state actors such as the private sector directly accountable still to date. There are the Ruggie principles that call on the private sector to respect human rights, that call on states to protect human rights, including by regulating fossil fuel companies and to provide effective remedies when the private sector harms human rights. But there is no directly binding treaty, although one has been in negotiation for a while. But for the private sector, I think a couple of other initiatives are very exciting, actually, and also more confrontational. More confrontational tactics also seem to be working. I'm sure Professor Ottinger can talk about all of his incredible efforts to call for an end to fossil fuel subsidies, including in a very key IUCN resolution that he and others helped push through. There's also climate litigation now, and at least one promising case, I think it was in the Netherlands, of holding the Shell company responsible using human rights standards and calling on it to cut emissions. But I finally wanted to really bring attention to the role of direct action, including by movements led by Indigenous communities, and in literally stopping the building of pipelines. And a report that the Indigenous Environmental Network put out showing that Indigenous-led activism helped stop something like what they calculated to be a quarter of the total greenhouse gas emissions through that direct action. That's really profound and perhaps much more impactful than any other means that we've been talking about. And to come back to Ankit's point about lawyers and accountability, lawyers are also needed there to help defend those actions against criminal prosecution and to push back against the kinds of slap suits and other legal measures that are being taken here in the United States and elsewhere to quell that kind of protest, something that a student of ours, Dana McClure, has actually written about. So I would just, as we think about corporate activity, we shouldn't forget Indigenous-led activism to use direct action to stop fossil fuel emissions and the building of more pipelines.
I'd just like to jump in very, very quickly. I agree with Professor Popovski and Professor Narula on these different ways in which we collectively need to address responsibilities and accountability for private actors. Just like to add 2 points to that discussion, and where I really think the international law dimension is important here, which is the effort for a legally binding instrument on business and human rights, as was pointed out. I've been involved with that quite closely. It is stuck, as you know, but over the years that I have been involved with this whole process, I've come to a realization that the whole problem is about a gulf between a Western construct or a Eurocentric construct of human rights on the one hand, and a non-Eurocentric idea of human rights. I'll tell you where I come from on this point. This is the issue of whether there are duties on related to human rights or international law in general on non-state actors. I was in conversation recently with a scholar from Ghana, and she pointed out that when I go to my village and someone asks me what are human rights, what do you do? What does this mean? She said, I have to begin with the concept of duties. I have to explain to them that I have duties to you and therefore you have rights. It's not the other way, that you have rights. You know, the source of rights is because I have duties to you. This is very much inherent in Ubuntu, in many different forms of ancient civilizations, in the concept of dharma. So the whole idea that only states have duties under international law is a very, very Eurocentric idea. It's a very Western construct. This whole discussion, I think, is important. If we look at the African Charter on Human Rights, it contains an exhaustive chapter on human rights duties, not on states, but duties of human beings and non-state actors. The American Convention contains an entire chapter. It's of course one article, but on duties of human beings. Look at the European Convention, has zero concept of duties, has zero concept of collective rights. All rights in the European Convention are only individual rights. There's no collective rights. You can't go to a European court and claim violation of human rights. And what's really interesting about this framework is that under the European Convention, corporations have human rights. So corporation can go to a European Court of Human Rights and claim violation of its human rights, whereas there is a complete denial of the duty dimensions. So I do think that at some point, and this explains a lot of different issues in terms of the debates on who are the duty bearers. Now, nothing theoretically in international law prohibits states from getting into a room and recognizing that non-state actors have duties. The Rome Statute has done that for individuals. The Business and Human Rights Treaty is attempting to do that. So I think it really ultimately boils down to what is the right template for understanding human rights and which template ultimately prevails over the other. I'll stop there. Thank you.
Fantastic. Thank you so much. And I see we're short on time, but I think I saw Professor Kakar, your hand go up. I think maybe we've got 2 minutes and then I'm going to have to give some closing remarks.
Katie, do you want me to speak now?
Well, I saw your hand go up, and I think we have about 2 minutes if you wanted to jump in or to comment.
Yes, I would. Thank you very much. You saw me leaning on the computer screen. My hearing aid is not working very well, but there are a few points, not from a legal point of view. I'm not a lawyer. When we were discussing in the UN General Assembly Open Working Group on SDGs, the formulation of an SDG on climate change, there was considerable opposition from some member countries to have an SDG on climate change, particularly from developed countries. And they said this sort of falls under the purview of the UN Framework Convention on Climate Change, and we should not mention it. Eventually, of course, we did have it, and it was included, but with a footnote. No other SDG had a footnote. This one had a footnote which called acknowledging that the UN Framework Convention on Climate Change is the primary intergovernmental forum for negotiating the global response to climate change. It's very difficult to implement all these agreements, whether it's UNFCCC itself, Kyoto Protocol. I am reminded here of Principle 7 of the Rio Principles from the Earth Summit in 1992. Common but differentiated responsibilities. All countries have common responsibility to reduce emissions, to control global warming, but differentiated in the sense that developed countries which had contributed to the increase in emissions had responsibility to support other countries financially, technically, and from other points of view. So that principle of common but differentiated responsibilities somehow got diluted as we got to the Paris Agreement, which of course for the first time mentioned in its preamble the question of human rights. No other climate change agreement had that reference. That was the first time. So the common but differentiated responsibilities got diluted as we got to Paris. But something that has been missing, I think, in our discussion is the plight of the smaller island developing states. What is their legal right? I mean, they will disappear from the face of the earth in 50, 60, 70 years. Of course, some developed countries say, all right, you can come and settle down in our country, but what about—
And I think, Narinder, that's a perfect sentiment to motivate a call to action as we end our discussion. And I wanted to, before we all log off, to give a huge thanks to our global environmental law fellow, Claire McLeod, who I'm sure died 1,000 deaths this morning as she watched the Zoom, but I appreciate your aplomb in handling an awful situation. And once again, I did want to take full responsibility. Achinthi and Claire, we had discussions about whether to hold this on a Zoom webinar or on Zoom, which creates the risk of a Zoom bomb. And it was entirely my decision. I was hopeful to have a more community-like feel to the discussion and allow people to ask their own questions, which is why we elected to do it this way. And that's obviously turned out poorly in this regard. And I think the best solution is just that we are going to have to find a way to come together in person again soon so that we can have discussions unfettered by the technical and other difficulties of a Zoom environment. So hopefully conditions will continue to improve and we'll be able to be partners in person once again in very short fashion. And we will edit out the Zoom bomb portion and then post a recording to this event. I know, Vesselin and Mihir, you had mentioned that many of your students were in classes or otherwise not able to be here today, but hopefully they'll be able to watch some of the discussion. And I'd just like to thank all of our panelists and especially our student interlocutors. I thought this was a really wonderful discussion, and to the extent something that will help me sleep at night is knowing that we have this next generation of students who are studying and working on these issues, and we look forward to supporting you all in your efforts. So thank you everyone.
Thank you.